impact on the role of state and local governments, and third, corporate tax avoidance and how that completes the loop, really, of exploitation of the world's economy. And those are the topics we cover. They are all of one piece. I had a PowerPoint presentation I had hoped to use, but I'm sorry that it's not going to work. I'm still going to use the computer because with my aging eyes, it performs a function in terms of useful notes. Before we get started, I want to test a little bit. How many folks here have dealt with the issues of involving questions of the balance of power between the state and the federal government and the international trade agreements and the effect on state sovereignty? How many folks are? Three folks maybe here. State taxation of corporations. How many folks have a background in that? I know we would have one for sure. Okay. Well, we have kind of a mixed audience background on these topics. Let me also indicate that this is going to get to be a boring hour and a half if you don't interrupt and ask questions. And so please do so. And if you want to just stop and discuss something among yourselves and with us, please do that. Should we? I suppose for airflow purposes, it's better to keep it open. Anyway, I want to start out a little bit by talking about the role of state and local governments in our federal system and why it's important. How many people are here from outside of the United States at this session? Everyone here is a U.S. citizen, okay? Because it'd be interesting if some of the Canadians were here because they have a federal system as well. But for a long time, federal systems were really unique in the world. And that's one of the things that makes states and localities vulnerable to trade agreements, is that other nations around the world do not have federal systems. They have central systems where power rests in a central government. Now, the United Kingdom was that way until recently, and under the Blair government, the current government, there's been a move towards devolution and really the establishment of a system of federalism in the United Kingdom. Particularly important is the establishment of the Scottish Parliament, and I'll refer to that a little bit later. And there's other trends towards federalism around the world. But until recently, while federal systems are still in the minority, and as a consequence, they're sometimes hard to fit into the context of international agreements because other governments expect that the U.S. government will give assurances that they will change state and local laws to conform to whatever the U.S. government is agreeing to. And that's not the way our system of government works. And our system is really, especially given the scope and size of our country, has really been important to this nation. And it has many attributes, and if I had my chart up, I'd start out by saying that state and local governments are really essential to guaranteeing democracy in this country. They provide a counterweight to the federal government. When the federal government engages in excesses, most recently, if I'm corrected, someone correct me if I'm wrong, when Attorney General Ashcroft decided that we should not know who was being detained, it was a state judge in New Jersey who said, no, for those who are being detained in New Jersey, you have to reveal the names. Now, that's been appealed, and he's been reversed so far, but that matter is still working its way through the court system. Yep.
Another example of that would be in Oregon, where he said that the doctors would be able to give out drugs under the state law for end-of-life choices and decisions, and he was overruled by a federal court. Now, he's appealing it, but he was ruled out of order, and that because of the state law. We were just at a panel discussion with Neil Sorensen and some others, and he made the point that in the NAFTA agreement that there is a place for, like, Montana's environmental protection right to fund small statements in our state constitution in the United States, that because of the state-federal thing that you're talking about, that there's rights there for Montana people to raise the issue of whether the NAFTA is treating us fair under state law as opposed to under the federal law having to just give in to just about anything because of the federal.
And there are, that would become, I guess, a case and would become a case of determining whether or not the national supremacy would overcome the state constitutional provision, given that these are congressionally approved trade agreements. Now, we could lead into a direction. Lawrence Tribe, the rather famous Harvard law professor, testified before the Senate Commerce Committee when the Uruguay round trade agreements were up for approval. And he said that he thought the trade agreements were so important that they should require a 2/3 vote in the Senate as a treaty to clearly override matters because they were affecting state powers. And he identified the interaction between the trade agreements and the powers of the states as being the critical issue involved in the trade agreements. Now, he made brilliant testimony a few days later after the Clinton White House informed him that maybe he wouldn't have a shot at becoming appointed to the Supreme Court. He recanted formally all of his testimony before the Senate Commerce Committee. And the testimony was excellent and is still on the record. But he said, well, maybe I made a mistake in terms of what I was advising. I was disappointed. But
the point, if I'm understanding you right, though, you're trying to make is because the power is not all centrally located in our government, that whether or not some of these rights at the state level are tested or the sharing of powers is tested in regarding the specific things on the world scale, that they are areas to test things and areas to try and bring out our form of government.
And one of the things is that one of the areas of test that came out of Tribe's testimony is if the trade agreements are approved. Trade agreements are traditionally approved by a majority vote of both houses, the House and the Senate. The Senate, the Uruguay round agreements passed by a 2/3 vote. If it had passed by less than a 2/3 vote, there would have been a case to be made that they were not properly approved, and a challenge. That's what he was arguing, that a challenge could be made on those grounds. Now, the Uruguay round agreements passed by that amount. The trick would be to bring a challenge against an agreement that was passed as a trade agreement by a majority vote in the Senate and not by a 2/3 vote, and to test that. That's one avenue that I understand. I'm not an attorney. I've learned this from listening to Lawrence Tribe before he recanted his testimony. But there's another point, this point about the tension between this whole area in the trade agreements, about the balance between the federal government, the rights of foreign parties under the trade agreements, and the states is really critical in virtually every area of domestic policy. And one of the problems, and I'm going to talk a little bit about a case called Beer 2, and it was about beer. It was a trade dispute with Canada, where the dispute panel literally said that they did not have to respect the U.S. Constitution. And that was and the rights of the states under the Constitution, because it involved state laws. And that's one of the things. And this is not resolved. This stuff is all out there in limbo. And the reason this is so important is because people don't think about, and I think sometimes I think progressives forget about, and here I'm talking as an individual, progressives forget about the importance of state and local governmental powers. Now, maybe it's changing a little bit, but many of us grew up in the civil rights movement when states' rights meant discrimination against minorities. And that, in fact, if you look at the long historical picture, is really an aberration in the role of state and local governments, and was really localized to local. Not that state and local governments are always right, but we forget that it was state and local governments that first began fashioning programs like unemployment compensation, for example. Progressive income taxes started at the state level, not at the federal level. A lot of concepts that became later national policies and programs and domestic policies really began at the state level, because states are accessible to and responsive to citizens in ways that the federal government is not. And sometimes, and more recently, the federal government has been more responsive to large corporations. State and local governments provide vital services and protections to citizens. And more recently, I've been proud of what states have done. In terms of state attorneys general that led the fight against the tobacco companies, that knowledge was there for a long time. It was not the United States government that moved. And we had, during this period of time when the knowledge was there, we had both Republican and Democratic administrations that could have moved on these matters. You had the Attorney General of New York bringing the suit against Merrill Lynch and other companies for basically what I would call fraudulent activities. I'm not sure that was a term that was involved, in terms of misleading investors. And I think you have other cases of where, in fact, in general, state and local governments do a better job at protecting consumers than the federal government does. And one of the things that has been happening recently is that there's a trend towards the business community in both regulation and taxation to want to preempt state and local laws. And deregulation has been one of those vehicles. For example, deregulation of in the transportation and trucking area has left consumers subject to great abuse by moving companies, for example. That's an area that used to be regulated at the state level. That's a function that is really too far away from Washington, D.C. to perform, and nobody performs it. And people, ordinary citizens, who don't have the wherewithal to sue, lose thousands of dollars each year because of inadequate enforcement at the federal level. And there's a real tendency to want to compromise the power of state and local governments through corporate and business interests, wanting to mandate deregulation at a national level and preempt, as a part of it, state authority. Back in the securities area, that's one of the disputes in the legislation to try to strengthen federal regulation of the securities industry, is an effort to try to undermine the existing regulation at the state level on which Attorney General Spitzer from New York undertook his action. And that. Anyway, state and local governments and finally, they save scarce resources of society. There's a lot of economic research that says that it really is true, that when you have separate units of government that are tailoring services to local needs, it's more efficient than if you try to do it all from a central government, especially in a very large country such as ours. Those are some of the things that I think that protecting our sovereignty is important, the sovereignty of the states. It belongs to the citizens. Now, in terms of the role of taxing authority in the hierarchy of things, I think tax and regulatory authority is absolutely critical to sovereignty. There's other things that states can give up to do. But if they give up their taxing authority and their jurisdiction to regulate to the federal government, they're giving up fundamental powers. And taxing authority in particular is important. When the Scottish Parliament was formed recently, the citizens of Scotland were asked two questions. Number one, do you want this Parliament that's separate from the UK Parliament that meets in Westminster? And they said yes. And then the second thing that they said, were asked, was do you want to give this Scottish Parliament independent taxing authority? And they said yes to that by a large margin as well. And you say, what, they voted to tax themselves more? Give authority to a parliament to tax? And yes, they did. And the answer from a leader of the Scottish Parliament, and then the movement towards the Scottish Parliament gave, is he said very wisely the following thing. He said there is no independent policy without independent revenues. And so, for example, bringing it home here to Montana, how many of you are from Montana as opposed to outside the state? Okay. But a little better than half in that. Here in Montana, we have a coal severance tax. And half of it is put in a trust fund to clean up the problems in the future that come from the mining of coal or other mining activities, presumably in the state. Our future unforeseen environmental policies. That tax, that coal severance tax, was tested in court and found to be valid under the U.S. Constitution. And as a consequence, the citizens of Montana have a very conscious policy to use that money in a certain way. If they were subject to control, like the tax system of Montana was subject to control in Washington, I would bet a whole bunch of money, if I were a betting person, that the utility companies in this country would have gotten a bill through Congress preempting the state's power to tax coal. But the fact is that we have the authority to undertake that independent policy, and you can't have an independent policy that fits the needs of your states without independent revenues. And in particular, a critical piece of legal authority of the states is the ability for residents of the citizens of the state not just to tax themselves, but to tax the commerce that flows into their state, to tax a fair share of that commerce. And the U.S. Supreme Court says that consistent with the Interstate Commerce Clause, as long as you don't discriminate against interstate commerce, for example, say that an out-of-state corporation is subject to a 7% tax and an in-state corporation to a 3% tax, as long as you don't discriminate in some manner against the out-of-state companies, you can tax a fair share of the activity of the companies in the states. And that's the right of the states to do so. Now, why is that critical? That's critical, and especially to an extractive industry state, is because if you have companies able to come into the state and use the services of the state and get the benefits of the state's activities and not pay a fair share, your economy is being exploited. And part of what we're going to talk about later is how that exploitation is in fact occurring on a de facto basis, both of the states and more importantly of developing regions around the world. The ability to tax companies that participate in a state's economy is absolutely critical to citizens preventing the exploitation of their state, and from having to provide services to having to provide a free lunch to those who are using the services. So that power is absolutely essential. Now, I'm going to try to wrap up the section in general on state and local governments a little bit with an elementary reminder of what state and local governments do. One of the things that's frustrating for me in the public finance realm is that when the popular press talks about public finance, most of the time they talk about the federal government. But the federal government comprises only half of the public financial system in this country. State and local governments are the other half, roughly speaking. And in fact, outside of Social Security and Medicare, the largest single public enterprise in this country is the public educational system. Roughly speaking, we spend $500 billion a year, $500 billion a year on public education, from early childhood education on through the university system. The Pentagon budget, even though it's growing rapidly, is only up in comparison to $380 billion a year. It's the largest enterprise in this country. Now, one of the things that really concerns me a great deal is that the business community, the really large multinational companies, say that they shouldn't pay, they don't have any obligation to pay for a share of the educational system. That's what they tell us. When I talk about the benefits of education, they will respond by saying, that's not our responsibility to help pay for that. We don't get benefits from that. Never mind the fact that the educational system it spends a lot of money to tailor the needs of the future, to meet the needs of the corporations for a future workforce. Never mind the fact, and this is one of the points and tensions, I'm not trying to stay out of technicalities of this, but never mind the fact that we know that education increases incomes. And when incomes increase, people buy more. And that creates more sales and more profits for corporations. Yet one of the points of tension in tax policy today is that companies say that just because we sell into the state we shouldn't have to pay taxes unless we are also physically present there. And that's one of the points of controversy today in areas of state tax policy with respect to corporations. They say, oh no, we're not there. Just because we may be making millions of dollars in sales in the state, and yes, oh yeah, that helps our profit line, we're not really there. Never mind the fact that that if you fail to pay your bill, they'll take you to court in this state, or in the state where the sale is being made, and use the court system to collect that debt. Never mind that they ship their products over the transportation systems that are financed to this country, by these state and local governments. And never mind the fact that it is because of the educational system that the residents were able to earn higher incomes and therefore have more money to buy the product in the first place. And yet they say they shouldn't have to pay a share of the taxes in the state. And that's a point of attention that we'll talk about later. There's a lot of other important things that state and local governments do. They spend about $300 billion a year on income maintenance and health programs, over $100 billion on public safety, transportation about $100 billion, the environment about $80 billion a year, community development about $25 billion a year, and other activities comprise about $200 billion a year. State and local governments are important to the quality of life of our society, and quite frankly, the best thing I can say, maybe the best way to illustrate this, if you study school finance, you'll know, or local finance, you'll know that houses never support the public services that they demand. That you have to also tax the business activity associated with the houses to be able to balance the books at the local level. At the state level, what the large corporations are increasingly saying is that you should tax only your residents for these services, and you should not tax a fair share of interstate commerce. If we are put into that position, quite frankly, state and local governments will not be able to perform the functions that they have historically performed to good credit in our society. Now, I'm going to stop here for a minute and really switch over to a discussion of trade agreements in a minute and turn this over to Greg to talk a little bit about it. But I'm going to stop right here in terms of the general background on state and local governments, what they do and why the authority of citizens and the sovereign authority of the states that really belong to their citizens to tax interstate commerce is important. I want to ask if there's any questions or points of discussion. Yeah, John?
About the state sovereignty issue, the State Insurance Commissioner regulates the sales of insurance and companies that are not following the law. They're allowed to exclude them from doing business in Montana. In the other panel that I was in, that I mentioned a minute ago, they talked about the fact that corporations, I don't know if it's entirely or in the main, are state chartered, and that just like in the tobacco thing, a lot of states got together and dealt with some national issues with state cooperation, that if corporations couldn't operate under those state charters, especially if a number of states refuse to charter them or something, that there's a states' rights issue and state sovereignty issue there that has an effect on what corporations will or won't do. And they're looking at their bottom line, and if there's enough states that won't charter a corporation, that can affect their bottom line. So that there is power that isn't used. The State Insurance Commissioner may use it at some levels, and other parts of state government may use that, but it may not be thought of as broadly what that power might entail if it were used more broadly.
I think we've got an expert here on corporate chartering and state of Dean. I think you know something about this in terms of the history, if I don't want to put you on the spot. But the state charter authority over corporations, be it insurance that you're referring to, and it may have more operational effect. But in many ways, state governments and the citizens of the states have receded from powers that are there. And there was a series there was a race to the bottom in the late 19th century as to how weak the chartering process could be. And there are some people who are advocates that states could exercise more authority over the activities, the business activities that are entering their state from outside, if they took the chartering process more seriously, and that there's untapped power there. Am I correct, Dean?
That's a very good characterization. It's latent authority that remains for the states.
And this was a point made, and that we overlook an awful lot of things that we, as supposedly smaller than the federal government or world corporations and everything, we overlook some of the power that we might be able to take back that's there.
But I'll tell you what happens. We're going to talk what happens. As soon as a state is perceived as getting the least bit out of line, the lobbyists are in the legislature playing the job card right away. Saying, if you do this or persist in this practice, we will not invest in you. And quite frankly, legislatures in general across the country get very worried about those situations. And they tend to allow that playing of the job card to be effective.
And the more poor your state is, the more power they have to come in and say, you're a business unfriendly state. In like Bangladesh, we're looking for a place where we get done with the least regulation.
Right. And that's what, which makes, and you alluded to it, makes cooperative states among the states holding hands together. And in terms of the keynote address last night, one of the things that is not happening as much as I was aware of earlier is that the people who want to protect the authority of the states are not holding hands across the borders in the same way that they did maybe 20 or 30 years ago. But holding hands together across the borders of the states is one way to counteract those kinds of influences.
Well, and they've done it for a revenue source on the tobacco settlements, and you were just pointing out a minute ago that they might be able to do it as a revenue source for education because there's some responsibility that resides outside of us as individual taxpayers.
I just want to say that Montana is the Bangladesh of the Rockies, and that we've got a 10-year process going on here to take all taxation away from corporations and businesses, particularly with the business equipment tax, and now with a governor who's decided that we turn out to be one of the only states in the country that has a capital gains tax that is progressive. It isn't like the federal capital gains tax where you get a break for selling stock versus having wages, and she wants to change that too. So this state has its own really special problems, and I think worse than any of the states around us, the way that direction is going, and you've characterized it correctly.
Well, I can't do. There are horror stories in other states as well, that process goes forward everywhere that I see it. When any state is perceived as being in some way out of line, the job card is played, and played with some effect.
I get to hear the lobbyists a lot.
Yeah. Trade agreements and their effect on the rights of citizens and the tax system. I want to come back to the tax system a little bit, but I'd like to have Greg visit with us about, or turn it over to Greg and visit with us about trade agreements and what it means for consumer protections and that, and then come back to taxation a little bit later.
John, the point you raised is a great segue into this. Now consider this question. At what point does a state's refusal to charter a multinational corporation to do business in their state a restraint on trade that can be invalidated by the WTO?
Yeah.
And that's exactly where we want to go here. Let me tell you a little bit about myself. I teach at the University of Montana Law School, and I'm not here as a representative of that law school today. I teach insurance there. I teach trial practice, pretrial advocacy. I'm also a plaintiff's or consumer trial lawyer and have been for 27 years. And in my field, I've been concerned about safety standards in health, in food, in transportation, the medical industry and products. I've been concerned about protection for workers and occupational safety and health, protection for workers in their jobs from wrongful discharge, and protection for workers in their compensation when they're injured on the job. So my interests have all been in standards for the protection of people. And I've been alarmed by what I've seen. Given my background, I have to tell you that I have a political lens through which I see things. And the political lens today tells me that the issues in the United States aren't Republican versus Democrat and aren't liberal versus conservative. But I see things as corporate power versus consumers and individuals. And I've just come to view it, and I tell you that as I start into this. I've seen it attributed to Ian Fraser. I'm not sure if he's the one who said it, that capitalism destroyed communism was about to do the same to democracy. And I think that's what's alarming people. I want to tell you a couple stories as we start in here. In Mississippi, there was a case. There's a tremendous black trial lawyer down there named Willie Gary. And Willie Gary had a case a few years ago against the Lowen Group. The Lowen Group is a multinational corporation, a Canadian outfit that owned 900 funeral homes in Canada. Very, very wealthy. They spread into the United States. Their forte was buying family, independent businesses in the United States, and they were buying funeral homes across the country. As I recall, they had a couple hundred in the United States. And Lowen Group at some point bought the Mississippi Funeral Home and also bought a funeral insurance business. And they committed a really egregious fraud on a bunch of people in the area in that insurance business and in the acquisition of that funeral home. They went to trial in Mississippi. Mississippi law provided that they could call a multinational corporation into a jury trial, just like our law in Montana does. The law provided that they could be tried on fraud claims there. It provided that the plaintiffs could receive compensatory damages, the damages for their injuries, and punitive damages. And the punitive damages, or exemplary damages, are damages that it takes to persuade a corporation that they should not engage in misconduct. Under Mississippi law, the jury was allowed to be advised that they could award that amount of punitive damages that it would take to keep that corporation from engaging in that conduct and from making the very lucrative revenue that they were making by engaging in the conduct. The jury ultimately awarded a $500 million verdict. Those verdicts, and most of that was punitive damages, by the way, those verdicts are reviewed by appellate courts. In fact, in this case, Lowen settled the case at that point for they said they were going to appeal, settled it for $129 million. And then they filed a complaint with the NAFTA court, as I'll call it, and a secret panel at NAFTA for $725 million against the American taxpayers on the ground that that verdict was an illegal restraint of trade under NAFTA. Couple of other stories, and that hasn't been resolved yet. Methanex, a Canadian producer of chemical, banned in California. California banned the chemical. It was an additive in fuels. Methanex sued the state of California, I think, for $525 million again. It's a lawsuit against the taxpayers. In California, Metalclad was a U.S. company that wanted to have a waste disposal site in Mexico. The Mexican government, and I believe it was a local Mexican government, refused to permit. They sued Mexico under NAFTA and sued the Mexican citizens to recover hundreds of millions of dollars because of the refusal of that permit. Now, and the same thing can happen here under NAFTA. The ironic thing about that is an American company that's refused to permit, if Missoula County refuses an American company, as they have, permit for a waste disposal site or an incineration site, the county and the taxpayers can't be sued for that. But we have, in effect now, trade agreements under which American taxpayers can be sued by multinational corporations for decisions that the local governments have made.
And the decisions by NAFTA is in secret.
They're in secret. And often the actual party to the event is not a party to the suit. It's a suit between the party suing.
They can't go in. California can't go in and speak for itself in the suit against it on the gasoline additives. they have no standing to speak for themselves. This was talked about in the
Yeah,
other.
that's very commonly the case. The real party that was involved won't be in this thing. And the WTO is that way. The parties to a case that's in front of the parties who were originally involved in the matter may not be involved with the WTO. And we'll talk about that some more. And that's one of the things I want to talk about here. And by the way, the clause in NAFTA under which this came about was a clause that was purportedly inserted because the Mexican government did have a history of seizing foreign companies and properties. And so it was purportedly to keep them from doing that, but the language has been used to say that any time you harm the interest of a multinational corporation, your country's taxpayers have to pay if it's deemed to restrain on trade. Dan talked about features of state and federal government. I want to point some other things out here that are very critical because we're going to compare the WTO. In the United States national and state government, we have the system of checks and balances. So we've got that executive, and we're all familiar with checks and balances and how that works. Now, understandably, we're concerned about the fact, again, that in our system of checks and balances, we seem to have a very predominant influence by corporations in our Congress, in our legislature, in our executive. I'll assert that to a certain extent, those multinational corporations don't have that influence over the judicial system, either at the state level or at the federal level, with some exceptions. And that is why you see such a ferocious attack in the United States on the civil justice and even the criminal justice system and on the judiciary. The multinational corporations are waging war on the civil justice system, on the jury system, and on the tort system. Because they don't have the control that they want over the systems. And just as I indicated in the Lowen group, the civil justice system can call multinational corporations into a courtroom in any state, and a jury can call them on the carpet and can make decisions about their future. And they find that intolerable. And that's why you're seeing this constant waging of attacks going on. Nevertheless, we have that system of checks and balances here. We also have, in our democracy, participation. And we used to say one person, one vote, etc. But at the very least, what we have is participation by multiple interest groups, sometimes competing interest groups. And we have that going on in our legislature, that going on in our Congress. And I point that out because that participation and access by those interest groups is important when you compare it to the WTO. Rulemaking under both our state and federal laws in the United States, we have administrative procedures. So if you're going to make rules about what you're doing, you have to give notice to the public, and there has to be public hearings. And it's intended that people have access and have input into that. We have a deliberative process. Our democracy, for whatever it's worth, has a deliberative process that's going on in the judicial system, in the executive system, in the legislative system. And we have transparency. And we argue about these things, but we've got a transparency. We have freedom of information. We've got Freedom of Information Acts. Government documents are generally available. You read in the press all the time about some government attempt to keep something secret. But we do have freedom of information, and we do have the public meetings requirements. So we have notice of what government's doing, and we have accessibility. And we have precedent. When our courts act here at the federal, state, or local level, what they do acts as precedent. And if the United States Supreme Court does something, it's passed down the courts, the lawyers, the judges hear it, and they know that, we've got to change. This is the law. And all those things are important. What it boils down to is, with all its imperfections, it's that old saying that the American government is the worst government there is, except for all the others. And this really comes to mind when you start looking at the makeup of the WTO. Now, if you're like me, you hear about the WTO and GATT and NAFTA and all these things, and you probably don't have a great background in them, and they're not very accessible. They're extremely complex. So I want to take a few minutes and talk about that. GATT, the General Agreement on Tariffs and Trades, was born in 1947, 1948. And the idea was, after the war, we had a lot of experiences with high tariffs and with boundaries, and the idea was that the world needed to have a freer trade. And the interests originally were in things at the boundaries, tariffs, government subsidies. You know, is that an impermissible, or is that a restriction on trade when you've got a subsidized product traveling out there? And GATT only applied to trades and goods. It wasn't services back when GATT came about. When we talk about GATT, it actually is 8 rounds of meetings and negotiations that have taken place since 1947, 1948. And they had the Tokyo round, and later the Kennedy round, and the last one that Dan referred to is the Uruguay round that took place, and these rounds might take years. The Uruguay round took from 1986 to 1994, and the Uruguay round resulted in the birth of the WTO in 1995. And the WTO took off, and within a couple of years, you started seeing the feedback, and people started realizing, especially with the advent of Seattle, that there was something going on here that which kind of caught us all by surprise. Ultimately, when you hear about GATT, what it is a very complex web of treaties, amendments to those treaties, protocols, etc. And originally, as I say, it dealt with tariffs, and as the years went by, and you had the birth, not the birth, but the advent and the rising of the multinational corporations, it went beyond tariffs and export restraints to worrying about things that were deemed to be hindrances to trade. So the WTO came about in January of 1995. The WTO is all based on these GATT treaties and amendments that have gone on before that. And a little bit about the WTO. There's a ministerial conference. It meets every 2 years. It's the ministers of the WTO. And then there are 4 councils, and this is kind of interesting. Those councils, there's a general council that has the general supervisory authority. GATT at one time didn't have a secretariat. They didn't have a general governing body. But the general council is the overall supervisory authority. Then there's a council for trade in goods, a council for trade in services, and last but not least, a council for trade-related aspects of intellectual property rights. And I point that out to you because notice there's no council for the environment, there's no council for labor, there's no council for health and safety, no council for food, but there's a council for intellectual property rights. And I think that tells you something, and it's been said, and I think there's a lot of truth in it, that the WTO is the triumph of property rights over human rights. The WTO has all kinds of decision techniques. They can make their agreements, they've got amendments to agreements, they make decisions, they issue interpretations, they can waive certain requirements, and they have lots of negotiation and implementation procedures. And they have, and this is very important, dispute resolution procedures. These were developed in GATT over many, many years, over 40 years, but they have been elaborately now set forth in the WTO. They're called the DSU, Dispute Settlement Understanding of the WTO Charter. And this is kind of the adjudicatory area of the WTO. This is where the decisions are being made in these secret panels. GATT, the WTO, the multinational corporations, the concern has become not just tariffs, but what are the non-tariff barriers? And what they say is, listen, we've got to stop de facto discrimination in trade. It's, for example, suppose that Canada restricts the use of alcohol in aluminum cans when all of the Canadian industry uses bottles and the American industry uses aluminum cans. They would find that to be a de facto discrimination and an impermissible restraint of trade. So it's on that basis that they look beyond just tariffs, et cetera, and look, what's the de facto discrimination? And in that regard, there are these link issues. There are clear linkages that have strong interlinkages with trade. One is environmental rules. So they immediately, in the world of the multinational corporations, become suspect if you have environmental rules, labor standards and rules, human rights, monetary policy, and arms control and proliferation. These are all what they view as linkages and things that they have to look at. Remember that any WTO member, and there are 135 nations, I believe at last count, who are members of WTO, can challenge the rules or laws of another country as trade barriers. And that's not just the rules or laws of the federal government. They can challenge the rules or laws clear down to the state of Montana. So it's interesting at that point to start considering, and some people have, compared the UN to the WTO. And it kind of fascinates me. I'm going to talk more about the WTO as world governance. But it's fascinating to me that here in Montana, where we have this very substantial number of people who are very, very concerned about loss of sovereignty to the United Nations, and you don't hear a word from them about the WTO. And really, I think anybody would have to agree that the loss of sovereignty to the WTO and to NAFTA is a very, very substantial thing. Former WTO Director General Renato Ruggiero said, "We are writing the constitution of a single global economy." And they did it, and it's there, and it has no provisions for environmental protection, for labor, health, safety, food, anything. Those aren't there, but intellectual property rights are very well covered in there. Marjorie Cohen, a professor at the Thomas Jefferson Law School in San Diego, said something that I think is very chilling. The global transfer of economic and political power from national governments to multinational corporations is a disaster for human rights, the environment, social welfare, agriculture, food safety, workers' rights, national sovereignty, and democracy. And if you agree with her that this is a global transfer of economic and political power from national governments to multinational corporations, then you have real reason for concern. Just some questions that I throw out, we won't even answer them, but they're again, I think, alarming questions. To whom is the WTO accountable? You know from all your studies who Congress is accountable to, who the executive branch is accountable to, for whom judges are accountable. To whom is the WTO accountable? Who participates in the WTO? They have 135 member nations. The advisors are all from corporations and industry. Excluded from the conversations in the WTO are labor, environmental, human rights, social justice interests. And when you look at this body, the dispute resolution proceedings, I think it's true, and one writer has said, that the WTO rulings have upheld the interests of transnational corporations in every instance that an environmental, labor, health and safety, or human rights protection has been challenged as a trade barrier. Now, Article 20 to the WTO has some general exceptions to the General Agreement on Tariffs and Trade. One is if a law is necessary to protect human, animal, or plant life or health, and so you might get some satisfaction out of that. Secondly, relating to the conservation of exhaustible natural resources, if such measures are made effective in conjunction with restrictions on domestic production or consumption. Those exceptions, however, are subject to language that comes before, and the language says that they may not be arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade. Unfortunately, that is there, but I have to tell you, in the decisions that are made by the WTO in the adjudicatory process, that secret process I'm talking about, the rulings come about as though those exceptions that I just read you don't even exist. Let me give you some examples. Under the Endangered Species Act, we have a provision that requires shrimp nets to be designed in a particular way so that they do not catch endangered sea turtles. When the United States used that restriction to say that shrimp could not come in that were caught by companies who did not use those kinds of nets, the WTO took that up. It was challenged at the WTO, and they held that that was an impermissible restriction on trade. When this is actually a pre-WTO GATT ruling, that the United States banned the importation of tuna that were caught in non-dolphin safe nets, and the same thing happened. The WTO, or the precursor to the WTO, ruled that that was an impermissible restriction on trade. And one of the issues that comes up here repeatedly, and you've seen this in the United States, we get a group that becomes socially conscious and aware of some problem, health problem to people, or some toxic problem, and we move on the corporations and on government, and we make it known that we want that stopped, and government issues a restriction and says, in the process, maybe the product comes here and it's a safe product, but if the process harms human beings, or harms animals, or harms plants, or the environment, then it's not okay. And the WTO says, it's only, you can only look at the product. I mean, we have this perpetual problem with them saying, no, you can't look at the process. If you're looking at the process, that's an impermissible restraint on trade. And so these major steps forward that we made, the Endangered Species Act, the Clean Water Act, the Clean Air Act, those types of things, even our Civil Rights Acts that we made back in the 60s and 70s, now are being whittled away by an extra sovereign entity, a multinational entity that has captured this thing that's very powerful. Yeah.
I don't think you can overemphasize the fact that it's done in secret and the people that are affected and accused don't have standing. So if some foreign government challenges California for what they're doing and in essence sues the people of California for what the corporation has lost, California doesn't have standing to represent itself, speak for itself, speak at all, and that the people that are defending them in essence are part of this world organization. In other words, it's like the prosecution and the defense in a sense is on the same side, and the people that are affected and then accused of doing something have no ability to speak or right to speak.
It is. It's astounding. When you look at our court system, the judicial system in the United States, it's the product of hundreds of years of evolution. It started in Great Britain and evolved over here. And now we've got a court system that was designed in a few years and has none of the protections. It's scary.
I just want to make a little footnote to this. That's strictly true under NAFTA. We learned about that. The organization that I work for, the Organization of State Governments Dealing with Taxation, learned about that problem when we were looking at the Uruguay round agreements. No one caught it at the state and local level with the NAFTA. And one of the things we fought for, and we got some of the things we wanted, and this was one of them, that we could participate, the state government officials could participate in a proceeding if they were being challenged. Now, it's a limited right. We can sit at the table, but we have to be subject to the position that the U.S. government is taking. And we have to convince the U.S. government that our defense is appropriate in the particular circumstances. But we at least get in the room. And we had to fight hard to get the administration at that time to agree to that provision. And I'm quite frankly real proud of it. We fought hard to get that. The Attorneys General Association helped us with that, the NGA and NCSL to some degree, the Conference of State Legislature and the Governors Association. But it's still, that still is not enough.
It's not throughout all these organizations.
No,
these are just a single.
It's in the WTO, not in NAFTA. But it's a limited, we at least can sit in the room and sit at the table with the United States government and help to shape the defense. But the U.S. government the federal government has control of the defense.
And there's no appeal also, besides the secrecy.
And there's no appeal to American courts.
Right.
I mean, if you lose a WTO or NAFTA, there's no appeal to the American court system. There is an appeal in WTO to the WTO. And in fact, under some circumstances, these people we've said that could be parties can actually appear as a kind of what they call amicus, or friends of the court, as Dan says, at the so-called appellate level, the WTO. Now, one other thing I should mention is that in NAFTA, these cases I told you about, Methanex and the Metal Clad and the Rowan Group cases, local governments have now really put pressure, local governments and state governments have put a lot of pressure on the federal government. I don't know if they're going to get NAFTA turned around on this, but what they're trying to do is keep the federal government from extending and entering any more treaties where they give them the rights to do this to local law and to sue the taxpayers. It's a phenomenal thing to tell multinational corporations, if you feel aggrieved by any of this and that it cuts your ability to make profits, which it surely did, you can sue the taxpayers and get your money back. And I saw one estimate that last year the American taxpayers have paid $32 billion to multinational corporations that feel aggrieved because they couldn't make profit by violating our laws. That's an astounding thing. And I think, we all shake our heads, but I assume that it goes back to the power of multinational corporations in our own government in influencing them to enter these deals in the first place. And again, I'm mind-boggled when I realize that people that are so fearful of the UN don't see any problem here, or at least are not aware of the problem.
Greg, those cases are under NAFTA, aren't they?
Yes.
Yeah. It's a little less, again, another thing we bargained for in the Uruguay round agreements, it's very important, is the difference in NAFTA is that they can, I think there's a right to enforce, and there's this Chapter 11 that there's this right to compensation.
That's right.
In the other thing we fought for in the Uruguay round agreements was no private right of action, that the corporation could not take a dispute panel ruling and go directly into our courts and argue that it was evidence that the Foreign Commerce Clause of the United States overrode the state or local law. And that moderates it a bit there. But we had to fight hard to get that in the Europe, and the next time another round of trade agreements comes around, state and local governments have to fight again to put that in there. Now that doesn't mean that we're home scot-free, because what happens when you have a dispute panel ruling against you is that it authorizes the other countries to engage in retaliation against you. And the vulnerability of state and local governments is that what they will do is that if there's an issue with one state's law, the other countries can retaliate against products that are important in other states that are more politically powerful. States where perhaps the leaders in Congress are from. And you put on trial, in effect, a state. So it doesn't mean that the states are home scot-free, but there is a little bit of breathing room in the Uruguay round agreements that's a little better than the NAFTA agreements. And again, state and local governments got more active in trying to build in protections there. But it's still not enough.
I'm talking about the impacts of these trade agreements, especially the WTO, on our laws. And in the last example I want to give you in the environmental area is the EPA had requirements requiring that gasoline be refined in such a way that it was cleaner and not dirtier for our clean air requirements. And those were struck by the WTO as being more restrictive. And the consequence is the EPA had to back up and lower the standards so that we have dirtier air. Food safety. There are no minimum food safety requirements in the WTO. There are requirements saying that if you get more restrictive with certain levels, that's guarding against that, and saying the government shouldn't get too restrictive in their food requirements. And one of the principles that comes up is what we call the precautionary principle. Some people would argue with me when I say this, but as a general rule, the FDA works on what's called the precautionary principle. And that means you keep the product off the market until it's proven safe. Now, there are people out there who say that's a bunch of BS, that we don't do any such thing. But Great Britain, for instance, uses the precautionary principle with regard to beef hormones. And the United States is a big producer and user of beef hormones. So the EU said you can't use the beef hormones, and the United States went to the WTO and said that's an impermissible restraint on trade, and the WTO ruled for the United States. The United States said that they should have to prove with certainty that the beef hormones cause cancer, and if they can't prove that, they should get to be on the market, and we should get to put them into their country and across their border. The WTO agreed, and the EU still would not give in. And then the WTO fined them $115 million.
How does that deal with, let's say, labeling laws? Could the WTO go to the beef produced? So if the EU said, okay, hormones come in, but we require that stuff to be labeled, will the WTO then say, or the beef producers claim that, gee, you still haven't proven there's any harm, so you're violating our negative free speech rights, and so you can't force the labeling upon us, because there's no difference between that beef and other beef.
There's actually a labeling case. Gerber was marketing, as you know, they're marketing the baby formula all over the world, and they're marketing the baby formula in Guatemala. Guatemala knows that breastfeeding is far superior for health to baby formula. And the baby formula can even be dangerous, so Guatemala requires that the labels of anybody who tenders baby formula into Guatemala has to have on the label a confirmation that breastfeeding is better, or in some way better. And the United States State Department took that, threatened to take that to the WTO. That's all it took. They threatened to take it to the WTO, and Guatemala had to back off because Guatemala assumed that they would lose at the WTO on that. So now in Guatemala, their domestic companies have to have the label on it, and the foreign companies do not have to. And the Gerber's position was that we have an intellectual property right in our label the way it is, and you can't tell us how to change that label. Remember I told you the predominance of property rights in the WTO, and that looked like a winner when Guatemala looked at it, so they had to give in. Labor protection. The WTA, its only provision restricting products, or restricts products produced by prison labor. There's no provision restricting products produced by children, for instance. And there is no restriction for countries that violently repress their labor unions. So again, it's anybody's guess, or your guess, what happens if you take that issue up, the WTO. Now I contrast all that with, as I said, the intellectual property rights. The WTO was drafted in the multilateral agreements, is drafted with what's called TRIPS. That's the trade-related aspects of intellectual property. So that's all the protection for intellectual property. And under that protection, not just American, multinational corporations, there are cases where they have gone into countries, taken seeds or plants that the indigenous people have had, modified them slightly genetically, and then sought a patent on the thing. It's called biopiracy. It's one of the things that's made possible by TRIPS. Thailand came up with an AIDS drug that was very, very cheap. They were offering it in the United States. The United States threatened to take them to WTO on a TRIPS challenge for patent infringement, and Thailand dropped the drug, and it's not available in the United States. I told you the story about Gerber. One of the interesting questions now that comes up, and we don't know the answer to, but I fear that we're going to start seeing soon, because you know, the WTO came into effect in 1995, and so much of this was new and came out of the Uruguay round. But that's the question of when does this stuff shake down through the system and get back down to us at local government or the state judicial system or the federal system. So if the WTO decides that a particular American law, a federal law, a state law, or a regulation infringes fair trade, I don't want to say fair trade because they don't say fair trade, they say free trade. If it infringes free trade, in the American system, if the United States Supreme Court decides something, that's filtered down in the form of a written black and white appellate decision, and the courts below are bound by it. And so your federal courts are bound. If the Montana Supreme Court decides something, the state district courts are bound by it. The question is, at what point do American businesses, entities, governments, local governments have to pay attention to what the WTO does? And so when they make these rulings, what's the effect down here? Nobody sends us down a black and white decision saying, here's the WTO ruling, from now on you can't enforce this law in this particular way. And what's going to happen the day that when we start getting the cases where the United States Supreme Court is faced with a question, you've got a WTO ruling, who has to follow it? And historically, American courts have not picked up on and followed the rulings in these trade agreements. They really haven't. And so that's an interesting thing, and it's for the future to see what's going to happen. Well, and the last thing I want to say is, you know, what are the remedies? And certainly the organizations that are bringing the conflict to the WTO and trying to make clear to them what the problems are, obviously greater transparency. We need to know, the WTO needs to engage in notice and public hearings and have some due process so that people know what they're doing, what the rules are, have a chance to comment on it. In their dispute resolution procedures, they need neutral fact finders, some rules of procedure, rules of evidence, rules of ethics, all those things that the American courts have at both the state and federal level. They need an opportunity for public policy advocacy inputs. Publication of relevant documents, fast publication of relevant documents. Government today can produce documents overnight. We can get online and get them. And you play pure hell trying to get documents from the WTO, NAFTA, or anything like that. They need them faster and they need to make them accessible. And then greater access to participation in the entire process. And finally, clarification on matters of infringement of sovereignty. We don't know what this means, what the WTO even means yet, and how it's going to affect us. But already you can feel impacts clear down at the local level.
One question he has is maybe theoretical, is why do we need the WTO at all? And it's a question of reform versus just throwing it out.
Yeah.
So, are you advocating that these international trade organizations are reformable?
It's interesting to me that when you go back and read about there are a set of people who have followed everything that GATT's done, and they're the experts on it. When you read their books, there were times clear up into the 80s, clear up to the Uruguay round, where they questioned whether GATT would survive. But I don't know that anybody questions that today. The question is, can we survive the steamroller? I don't know if you get rid of the WTO. And so the question is, and I think it's a real valid question, do we need it, and do we need the reform? We have to have, international trade is a terribly important thing. We're going to have to regulate it in some way, and no given nation state can regulate it. So there's not much question of the need for it. But it has gotten where it is in violation of a whole set of democratic principles. And there are people who will argue and can show you that GATT itself requires and kind of assumes democracies. But the organization itself and the WTO now is set up on the most undemocratic principles.
What percentage of the WTO revenue sources is actually from the U.S.?
And I don't know the answer to that. I don't know, and I don't know where its revenue sources come from. If not,
This is a question by way of making a statement. If one hand is ho-hum, what's the big deal? The sun's shining, here we are. And the other end is, it's too expensive to fight a literal war on a worldwide scale because corporations will lose too much money, so they're fighting an economic World War III. We don't even know what's going on, and we're losing it. How close are you to feeling that the severity of all this is World War III on an economic level, and the American people and the people of the world in general, they know something's happening, but they don't see what's going on, that it's an economic war that's being fought, versus in the middle versus, oh, it's not a big deal. Obviously you're not on that end. But it seems to me that it's at a level of severity that threatens kind of human life as we know it so well off in this country.
yeah, for me, it comes down to this, the ultimate question is there any way to control the power of multinational corporations today? And that we're at the test. We're right there at the brink. Because this is, the phenomenal steps that were made in the 60s and 70s in the environment and human rights, et cetera, are on the line right now. And boy, I don't know, I'm alarmed. I don't know what to tell you. I don't know how to answer the question. It's just, all I can tell you is I'm really
It
alarmed.
makes Anaconda in Montana look small in the 20th century and what they can do.
I don't want to cut Dan's time off here to get to the tax aspect of this, Steve.
Well, I was just interested in the constitutional legitimacy of our role, U.S. government's role in GATT, NAFTA, whether all of the procedures have been properly followed. 2/3 of the Senate signing the law by the president, and the implications, I guess, of trading away. It's there in our Constitution that we can negotiate treaties with other nations, but on the other hand, there's no corresponding authorization in the Constitution to maintain our rights, to maintain our sovereignty.
One of the things that Greg, in listing the things that are not protected in the trade agreement, one of the things that's not protected is a system of federalism and precisely the balance of powers. And as I think Greg illustrated, there's a number of questions that are unanswered. And I want to just briefly go from the trade agreements quickly into the tax picture in this, and then give you the business about how the global trading system that's been enabled by the trading agreements, how corporations are treated or not treated for tax policy purposes, which is one of the functions of this session here. But just quickly, in the trade agreements, one of the things in the Uruguay round that our organization, the Multi-State Tax Commission, and a few others asked for was for the protection for state and local laws that is equivalent to federal laws within the trade agreements. Trade agreements say that basically, for the U.S. or any nation, that their legislative body has to agree to change their law that has been ruled against in a dispute panel proceeding. All that what the WTO can do is authorize economic retaliation, and that's been authorized in the case of a tax break called foreign sales corporations, which other countries have viewed as an illegal export subsidy by the U.S. government. Now, whether it is or isn't is a matter of dispute, but the U.S. lost the case, and now Congress is trying to satisfy that case, and they're going back and forth with the other countries as to whether or not they've properly done it or not. But the point is that Congress gets to pass a law. If a state law is struck down or a local ordinance is struck down, we asked for the following provision, that Congress has to either approve or at least be put on notice that the U.S. government was going to sue a state to comply with the trade agreement provision, because we said that state and local laws should have at least, Congress traditionally is the body to preempt the states. And we said Congress should say whether or not the Attorney General is going to sue the United States. And we had some technicalities there. We were asking basically for the same protection that the Congress provides for itself and is consistent with our system of law. We were turned down on that in the Uruguay round agreements. And that's one of the things that I think that because where it stands now is if we get an adverse trade ruling against a state or local law, guess what? The Attorney General of the United States, advised by the U.S. Trade Representative, can decide to undertake an action to preempt the state law, and in the technicalities, they would likely be successful. And we don't have the protection of going to Congress to get to be able to work the issue out. And that's one of the unresolved things. But I want to, if we can, I don't say you got to follow, but I've got a lot of ground we got to get.
Well, I just want to make a quick comment that it seems to me that we've created a fourth branch of government that our own government is subservient to. I mean, that's inclusive of all branches, the judicial, the legislative, and the federal and the state legislative branches of government. It seems that we've created this entity above our own framework.
One of the things, and Greg alluded to this, about how in and I want to, if we can move on here quickly, in the Gerber case and the Labeling case that occurred, that within Guatemala, the foreign companies selling in there have an advantage over the domestic companies that are selling. The way our organization, who works with taxation, first learned about this particular problem was in a case under the precursor to NAFTA, the Canadian-American Free Trade Agreement. And it was called Beer 2, because the U.S. won a Beer 1 round. Maybe that was I don't know if it was the aluminum versus glass bottle case. Well, the big brewers in Canada retaliated against the United States for the U.S.'s decision in Beer 1, or the decision the U.S. won in Beer 1 with Beer 2. And they challenged the entire regulatory and tax structure of the beer industry in the United States. And just in the tax piece, what's important to know is that we basically have taxes for major breweries up here, And in the 1980s, states enacted a number of tax breaks that provided a lower level of taxation for microbreweries. And I think everyone's kind of acquainted with the beer industry and microbreweries versus the major. We know the local examples here. Now, some of the state laws were in fact unconstitutional, probably, because they said it was a tax break for microbreweries only located in the state. But in Minnesota, for example, they had a provision that provided for a local tax, for a tax that was lower for all microbreweries, regardless of where it was located. And that passes constitutional muster as non-discriminatory taxation, because it doesn't discriminate against in-state and out-of-state. But making a distinction by size is a traditional thing in taxation. The federal government doesn't. S corporations, which started out as small business corporations, treated more favorably than large corporations. Progressive income taxation. Small incomes treated better than large incomes. At least that's the way it used to be. What have you. That's it. There's a lot of precedent for this. That's constitutional. Beer too. The dispute panel, secret panel, as Greg described, and said the major breweries, the major Canadian breweries, challenged this, and they got a decision that basically said that they're entitled to this tax treatment instead of this tax treatment. Okay? Now, this decision has not been enforced, except to advise the states that discriminated against out-of-state folks needed to revise it. The states that have been advised to basically eliminate this have largely told, and USTR, I guess, has asked the states to, that's the U.S. Trade Representative Office, to eliminate this differential. And most of the state legislatures have said, we're not going to do it. They've kept this in place. This is a latent dispute where the Canadian brewers could come in and ask for enforcement of this. They have not asked for enforcement of this. But what's interesting is that they could get better tax treatment than the major U.S. breweries. Well, what are the major U.S. breweries? How are they going to respond?
We should get two.
That's right, exactly. They're going to go down, and you go down to, there's other problems with this. Greg has covered the groundwork here, but and then if you reverse this, the same thing is true for U.S. companies overseas. They can go in and they can start the mechanism there, and guess what? You have a ratcheting down of taxation on interstate and international commerce. Who picks up the tab for that $500 billion a year in educational expenditures, for the $300 billion in income maintenance and health, et cetera, et cetera, et cetera? Guess who picks up the tab? Ordinary citizens and small businesses. And that's the mechanism here. Now, the trade agreements, we've got about 15 minutes left, and I've got about 40 minutes of stuff on corporate taxation. But what the trade agreements do overall is create a system of expanded global trade, largely, as other speakers have talked about in this summit, that is largely oriented towards the needs of multinational corporations. And I'm just, I'm not going to try to prove that. I think other speakers have addressed that. And basically it expands globalization. Now, one of the most important things to understand about trade, and it's talked about as free trade, is that roughly 30% of trade is controlled trade. That doesn't sound like free trade at all, does it? And the answer is, you bet, it's not free trade. Controlled trade is trade among different subsidiaries of corporate entities. That's 30% of the trade that goes on. And that's becomes very significant in the context of taxation. Now, I want to give you, keep that in mind, and I want to draw up here something I have on a PowerPoint here about state corporate taxes and what has happened roughly from 1961 to the year 2000. And if I want to to put the 1980s, the early 1980s in here. Basically what happened is that in the 1960s and early 70s, a number of states adopted corporate income taxes, and in the 1970s, they beefed up their enforcement significantly. And by the mid-80s, the effective rate of corporate income taxes, state corporate income taxes on corporations, reached a peak of about 9.5% in the mid-1980s. And then since then, it has gone like this. And it's down to about 5%, and in fact is probably headed lower. It's been cut nearly in half. Now, state legislatures have enacted some conscious policies to cut these things. But as far as we can determine from economic development incentives that are granted, for example, or statutory changes, account for only about 1/5 of this decline in the effective rate. The effective rate being the tax over the total corporate profits. 80% is because of increased, and I would label it excessive corporate tax planning. Sophisticated income shifting, both domestically and internationally. Now, one of the things that triggered this is that, and I want you to, here's a technical term I want you to become acquainted with. A number of states, a dozen states, most prominently California, but including the state of Montana, up until the mid-1980s, used a method of accounting that largely blocked all international and domestic income shifting, most income shifting. And it was called worldwide combined reporting. And this method stopped a whole bunch of tax avoidance activity, a good share of it. And because it was fair and effective, the multinational corporations launched an extensive effort to get this repeated. They tried to first go about it in U.S. Tax treaties with other countries. They got a provision in the 1970s in the tax treaty with the United Kingdom outlawing worldwide unitary by the states. One of the things I'm proud of is that my organization, which has employed about 40 people, unfortunately is not well known by the citizens of this country, and yet we spend every day of our working lives defending the tax interests of ordinary citizens. We're not well known in this country, but we were known by Margaret Thatcher. She knew who the Multi-State Tax Commission was, and she didn't like us because we stood for fair taxation of multinational companies. And our organization in 1976 defeated the UK-US tax treaty, was successful in launching a campaign that defeated the UK-US tax treaty that at that time would have outlawed this. And it's the only time a tax treaty has been defeated. Now, worldwide combined reporting was in effect at this particular time. But in the mid-1980s, and I've got to tell you this story, after the U.S. Supreme Court, in the container case in 1983, came down with a decision saying it was fair and constitutional. They've since revisited under the Foreign Commerce Clause in another case in the 90s, in the Barclays case. U.S. Supreme Court has absolutely approved this method of taxation for use by the states under the interstate and foreign commerce clauses. After the states won that victory in container, the multinational business community was very upset because they wanted this method killed. And they went to the Reagan administration, and the result was a report that asked the states to recede from this worldwide method and use it only within the borders of the U.S. And it is helpful within the borders of the U.S. But in exchange for that, the federal government was supposed to fix their failures to police international transactions where a lot of income shifting occurs and provide assistance to the states. And the federal government has done neither. And again, I'm going to describe the little problems as to how this income shifting goes in just a minute. But the point and one of the things, when this was under attack in Montana, because Montana was one of the states that used this, the Akio Morita, the late and former president of Sony, was also the head of what was the equivalent of the Japanese Chamber of Commerce. I think it's called the Conandrin, but I may not have that right. He wrote a letter to then Governor Schwenden, and he said, if you don't lead in getting your state to repeal worldwide combined reporting, we won't invest. There will be no new Japanese investment in the Montana economy. Now, Governor Schwenden, to his credit, didn't said, I'm sorry, I'm not going to take that bargain. No dice. The legislature, however, did, and they repealed worldwide unitary in the Montana legislature and moved to an elective water's edge system on the basis that there would be no new foreign investment in the United States. Now, I used to work for Montana at that time, and I work indirectly now with the Multi-State Tax Commission. And I have monitored since that time how much foreign investment has occurred in Montana. We have had one major Japanese investment. That was a dude ranch that was purchased in the Big Hole, that is where the cowboys take Japanese visitors around. That isn't, and those are no new jobs, and that was not had anything to do with our tax system, and it had everything to do with the beauty of the natural environment of Montana. Now I want to keep that in mind, because you may wonder what can be done. Let me give you some quick things here. The reason that line has gone down is for two reasons. Number one, the federal government is ineffective in holding corporations accountable for their income that is earned internationally. And number two, states have become increasingly less effective in policing these matters. And it's two things. But recently there were headlines out of Enron that, for example, the first thing that came out of the Enron debacle is they had sliced and diced their corporation into different units and subsidiaries, and they had all these offshore partnerships where they put the debt over there and left the supposed profit with the name companies in the United States, pumping up its stock price. Well, guess what? That would seem to say, well, if they were pumping up how the income statements in the United States look, that would mean that they were paying a lot of income taxes, right? No. At the same time, in 4 out of 5 years, from 1996 to 2000, even though they had high book income, they paid no corporate income taxes to the federal government or to any state governments. 4 out of 5 years. And how did they do it? At the same time that they had all these partnerships to manipulate their financial accounts, they had a different set and network of partnerships that were used, partnerships and subsidiaries that were used to shift the income away from the United States for tax purposes, a separate set. They were given names too, tax names like Tawny and Tamara and Tommy and this sort of thing, and they ran out of those names and they started using names of golf courses for these different deals they were running. And they did them so much that at one point, 30% in 1 year, 30% of their net earnings was in the form of one-time tax savings that helped in turn to pump up the stock price, misallocating capital, misleading investors. And one of the things, the corporations will say, oh, we only have the right to minimize our taxes. Guess what? They've taken it to the point that it's actually bad for the economy. Because what was good for Enron was bad for the investors. This masked, this 30% of their earnings being represented by tax savings, through manipulation. This masked the weakness of their underlying business and delayed the day of reckoning and the time period when investors, and particularly employees in the 401k plan, were left holding the bag. So tax planning is not necessarily good for the economy. It's not even necessarily good for the corporations that are, or for the investors in the corporations that are using that kind of tax planning. But what they did, they had something like 881 subs in tax haven locations to avoid taxes. And let me show you quickly how this is done. And Greg talked about why are intellectual property rights so important? Guess what? It's not necessarily for the protection, just the protection of patents and royalties and not patents and trademarks and copyrights and this kind of thing. It's because they're useful for tax purposes too. And here's how it works. We have a tax treaty with Luxembourg and the Barbados and some other places that go like this. They can set up a subsidiary, the Luxembourg subsidiary, and here's the U.S. company, okay? Here's the U.S. company. Now what you do is that you give the sub your patents or your trademark. You just give it to them. The intellectual property. You put the intellectual property over here and you give it to the sub. And what do? You pay a royalty to that sub. That royalty is deductible against the U.S. taxes. Bingo, tax deduction. Now, that's just one simple way. You don't have to send trademarks. You can send money and borrow it back at interest. And the interest is deductible. I'm just giving you, the tax schemes get much more sophisticated than this. But I'm giving you the kind of different version. You can, if you're using 881 subsidiaries, you know it's very complicated because what they do is other games where they realize losses in the U.S. offset by profits elsewhere and whatever. The games are very complicated, but this is one common way. Shift valuable assets overseas and then charge. It's done domestically. What you do is, and this is, Montana is not vulnerable to this domestically, but states that do separate entity accounting, that do no corporate combined reporting at all are. Just put Delaware in here. And over half of the corporate income tax states, the state legislatures haven't moved to combined reporting to solve this. But let's just say that this is a foreign sub here. And the reason that worldwide combined reporting counteracts this is that you put these pieces back together. You combine this together, all the income together, so you bring this income back to the United States, and then you apportion a share of this total income pie based upon factors called property, payroll, and sales, so the percentage of property, payroll, and sales in your state, which is the method the U.S. Supreme Court has approved for use by the states. Our organization has asked the federal government to use this system internationally, and the federal government refuses to do this. They use instead complex rules that attempt to unravel all the transactions piece by piece. Yeah.
Well, when you give your patent to the foreign company or sell it to the foreign company, can't the tax authorities go in and say how much that patent worth based on a licensing deal and try to retrieve taxes?
Oh yes, and you know what? In the last 20 years, the IRS, then this is called transfer price. Well, first of all, even if it's at the right price, it's legitimate. Now they can try to inflate it. You see, if it's under the U.S. system, if it's at the right price, they've succeeded. It's a royalty is okay, because it generated the deduction here. Now, you're talking about only if they're paying an excessive royalty.
Well, no, I'm just saying the transfer of the intellectual property to begin with.
No, it's not. I don't understand the details, but the transfer originally does not have to have a payment for it.
So they can just give away this huge asset to...
Well, they trade stock. This company gives back stock or something like that.
Oh, so it's unrealized gain.
Right. Okay. Yeah, they've long since covered that.
Are there states that still do worldwide combined reporting?
Well, Montana does for companies that don't elect the water's edge method. The companies that won't elect it are the ones who gain from it because they have losses overseas. But mandatory worldwide combined reporting isn't used anymore. I had a conversation. Now, internationally, this method was hated by the foreign entities, by foreign nations and foreign companies. I once bugged and had a debate privately in a small meeting with a European Union official on this. And this is one of the points I want to make that's important from the standpoint of this overall conference. I said, why don't you guys recognize that worldwide combined reporting is fair and equitable? And I kept on and I kept arguing, because I said, you are coming after the state when we in fact have found the right answer to this problem. And he said very simply, because he was just tired of arguing, he ended the conversation by saying, we in Europe do not want to have a conversation with our former colonies about the fair distribution of income. What he was saying is, we want to go, now I haven't finished this, we can take just a few minutes, but what they're saying is we want to go overseas, we want to be able to extract profits and not leave anything behind. Now it happens here in the United States. We're following this practice, we're doing this to ourselves. Let me give you another example of what is done. Is that another example of what is done is that you have a U.S. company that's well, they don't do as much manufacturing in the U.S. anymore. You know, we've shifted over here. And what you do is that over here in, let's say, Taiwan, or maybe mainland China, we get a bunch of parts manufactured, right? We get a bunch, and then guess what? We own a plant over here in Singapore. Now, why in Singapore? This is where we do the assembly of the computer, for example, in this case. Components built here, shipped to here, and then to the U.S. Orders going to these points, etc. Why Singapore? 15-year exemption on taxation for any new assembly plant. No taxes. So what do? Well, you sell from your contractor or subsidiary in China or Taiwan the parts to Singapore at cost. So no profit occurs here. So there's no taxes in these countries. Then you sell the product to yourself. This is the 30% controlled trade, because this is all controlled. You sell this product to yourself at the price that you're going to sell it to the consumer, less the transportation and distribution costs in the U.S. So there's no profit here. All of the profit ends up in Singapore. This is called transfer pricing.
That's illegal, right?
Yes, but the United States government has not won a major transfer pricing case in 2 decades. And you would expect in the tax area that the tax agencies would win about half the time, and the taxpayer would win about half the time. The U.S. government is batting 0, and the taxpayers are batting 1,000. And the reason why is that these transactions are so complex that they're impossible to police. They're supposed to readjust these to arm's length. It's impossible to do that. In a case against Chevron, in discovery, there were 1.3 million pages of documents that were produced by Chevron, and Chevron convinced the judge that they didn't even have to index the documents. That's in one case. That pile of paper, without any covers on it or anything to hold them together, if you just stack the sheets of paper together, is higher than the U.S. Capitol building. We calculated that out. There's no way humanly possible that you can, in anyone's lifetime, review those papers and try to figure out what the prices ought to be. There's millions of transactions a day. I once sat in on a conference of the American Electronics Association. I think they didn't think they wished I hadn't been there, because a representative of a major accounting firm was there selling software to the tax managers. And he said, we have a system here that will monitor you every day, will tell you what your prices are that you're charging around the world in these transactions. And we will tell you the tax results. And if you don't like it, you can send back a message, he called them a piece of software called bots, that will automatically go over your entire network and will fix the prices to achieve. You just say what the tax result is you want that day, and you'll get it. That's what it is. There's no way to police that. The only way to do it, and it's simple, and little states like North Dakota and Montana did this, and this is why it's so powerful. Worldwide combined reporting. Now there's other issues as well. This is not a sufficient answer, but it's part of the answer to the particular problem. And again, that's we've urged the federal government, my organization has urged the federal government to go to this system. The question is, when will the states decide to potentially return to this to police these particular matters? You look, the other one, and I have to commend Senator Baucus and Senator Grassley for recent legislation to try to close this loophole. The Bermuda escape. Companies in the United States are reincorporating in Bermuda, keeping their operations here, and because of the tax treaties and rules in Bermuda, they cut their tax bill in half or better in the United States, and that affects the states. Every dollar that's lost in federal revenue translates to 20 cents lost in state revenue. Now the same thing happens domestically for states that use something called separate entity accounting that quote, respects the separate corporate entities. Montana doesn't do that just domestically, and a number of other western states do not do that domestically as well. The point is, and the sad thing is, and one place to go to get more information on this is to read the articles in the New York Times that are being written this year by a gentleman by the name of David K. Johnston. He's a Pulitzer Prize winner, and he makes arcane tax things understandable to average citizens. And he's writing a good article a week. Just yesterday, he had an article in about big accounting firms' tax plans help the wealthy conceal income. One of the sad things is that these kinds of methods of international income shifting are being now adopted by people who are very wealthy within the United States. People who have, the example he gave is someone who had a $100 million profit from the sale of business. Now, most of us in this room, I don't think I would bet, are not going to be ever experience that sort of thing. But this kind of practice is being increasingly used by wealthy people as well. And the point is, and let me follow this again, the loop is that this global trading system makes it easier for large corporations to do business around the world, to extract resources from other countries, whatever their other countries are, regardless of where they're based. And then, because of the inadequacies of the tax system, not even pay their fair share of profits when it's brought back home. And that's my bottom line. And we're over time, and you've been patient. I can talk to you about things that can be done beyond worldwide combined reporting. Oh, I don't know what you want to do. There is a movement afoot to try to preempt state corporate taxes to the point where they're almost negligible by requiring, and this is what I was alluding to earlier, there's a movement afoot in Congress to require that corporations cannot be taxed in the states unless they're physically present. The Supreme Court standard is that you can tax a corporation if they're doing business in the state, regardless of the means by which they're doing it. But because of the advent of the internet, particularly and in banks that do business electronically with citizens, et cetera, they don't want to be taxed in a state just because they're making sales. They say, we're not earning income if we're making sales. I say, how are you going to earn income without making sales? It doesn't follow. You need supply and demand to earn a profit. You need to have both. So both the market state and the production state count. And the fact is that they're trying to preempt the states, and that's a serious problem. And maintaining a second measure is maintaining a strong doing business jurisdictional standard is important to protect the tax system, because that's really the intellectual property of the citizens of the states, including of every state in this country, is adequate jurisdictional authority. Companies defend their intellectual property rights. Citizens need to protect their intellectual property rights, and that is basically their jurisdictional standards. And that's and that applies not just to taxation, but other areas of law as well, in terms of holding companies that enter the state to do business in a state accountable for their actions. Overall, the big problem is that the ordinary wage earner in this country is expected to report all of their income, where they earn it. And it's become optional for corporations and the very wealthy, to a degree that, in fact, in my view, is scandalous. And anyway, I'm glad to answer any questions. We're over time.